Okay, hi everybody, welcome back. So this will be our second session on tort law, and we'll be finishing off vicarious liability, partially by way of revision because we got onto it last time, and then we'll be getting onto the first element of negligence, which is the duty of care. Okay, so the chat box is open if you've got any questions, and we shall be, as I say, covering the parts of vicarious liability that we covered before. Perhaps it's worthwhile flashing up our order of topics. So tonight we finish off vicarious liability, then we get on to what is in your course manual is 2.2 in chapter 2, the duty of care. Now the duty of care will be focusing on in general terms, and the course manual does also deal with duty of care in chapter 3, but in two particular instances. And these are where the damage suffered by the plaintiff is either nervous shock, that's what NS is, nervous shock, or pure economic loss. And what is pure economic loss? It's loss which is the result neither of personal injury or property damage. It's simply financial loss without, as a result, as I say, of any personal injury or property damage. Okay, so I don't know why your course manual deals with duty of care with regard to these situations in a separate chapter, because if I was writing the book, I'd put it all together under one heading, duty of care. And I've got a very good PowerPoint at the end of the next set of PowerPoints, which summarizes all you need to know about duty of care. Okay, so we haven't quite got to duty of care yet. We need to finish off vicarious liability first. Again, slightly strange while we're dealing with vicarious liability. If I was writing the manual, I'd put vicarious liability at the end of the study of negligence. Anyway, so let's go through vicarious liability. Remember, it arises out of various relationships. On our course, we restrict ourselves to the employer-employee relationship. You can also have vicarious liability in other relationships, such as principal-agent, car owner, and car driver. Oh, I noticed today walking to class that the police are now issuing parking tickets again, isn't it? So the driver, I'm not sure whether you'll have to pay. If he can't pay, then the car owner would be vicariously liable. And of course, remember what the word vicarious means. It comes from the Latin word vice, meaning substitute. And remember, vicarious liability fits in with the main function of tort law, which is compensation. So in the employer-employee relationship, vicarious liability says that the employer is responsible or liable, same thing, for damage caused by the torts of his employees acting in the course of employment. And the two key issues are the ones underlined: who is an employee and when is the employee acting in the course of employment. Okay, so we're going to be looking at some important cases there. I'll tell you the must-know cases as we go through. Your manual does have quite a few cases on those issues. You don't need to know all of them. I'll just tell you the must-know ones when we get there. And of course, generally, looking back, stepping back a bit, why do we have vicarious liability? Well, it means that if you sue the employee, you may not be able to have any judgment satisfied because the employee has no assets. So you can sue the employer because he is vicariously liable, and the employer would have much greater resources, particularly insurance. Okay, and so if you are starting an action, you sue both of them. Okay, so they will both be defendants. Of course, what happens if the employer does actually end up paying out? Well, then he might get an indemnity from the employee. Might also fire the employee, who knows. Okay, all right, so we're in the employer-employee relationship, and don't forget the must-know definition here. The employer is liable or responsible for damage caused by the torts of his employees acting in the course of employment. Okay, so the employer is strictly liable. What's that mean? He's liable even though he may not be at fault. Okay, And so why do we have it? Well, as I've just mentioned, point number one, the employer is usually insured, so he's a better target to sue. Remember, when you start a civil action, or you go through a civil action, two big questions. Is the defendant liable, liability? And then probably even bigger question, quantum of damages, how much can you get? And the third point, can you enforce the judgment? What's the point of going to court, winning a case, but then finding that the defendant is a man of straw? That's the expression we use. He does not have any assets. Okay, so the employer is a much better target to sue because he has greater resources, particularly insurance. And in Hong Kong, there's an employees' compensation ordinance you should be aware of. And the employees' compensation ordinance only applies if the worker is an employee. Okay, that's number one. And under the employees' compensation ordinance, the employee does get some money, not a great deal, but does get some. And if you are injured at work in Hong Kong, you'd actually start two separate actions. One is for under the ECO, the Employees Compensation Ordinance. Normally that would be in the district court, but you could also start a common law action for negligence if you've been injured at work. Okay, and you can get probably greater level of damages in the common law action. And if you do succeed in the common law action, any damages received under the ECO would be deducted from your award of damages in the High Court. Okay. And also the other justification for vicarious liability is that the employer profits from the employee's activities, therefore should bear any losses from the activities. Okay, so let's have a look at these two important issues. Who is an employee, and how do you know whether a worker is an employee or independent contractor? There are really only three must-know cases, and they're all on the screen. Your course manual devotes 7 or 8 pages to this issue, but really the main test is the person in business on his own account? And that depends on the facts of each case. In market investigations gives us the test, so it's must know. And the court uses indicia, they call it, factors if you like, such as provision of the equipment. If the worker provides his own equipment, that indicates he's an independent contractor. Who does the hiring of the helpers? What is the payment method? And other control factors. Such as, does the worker wear a uniform? If he wears the employee uniform, well, that would indicate employee. Okay? And as I say, it's an issue which doesn't have a black and white answer, as illustrated by these two cases, which both went to the Privy Council, Li Ting Sang and Cheng Yun. And in Li Ting Sang, the action went all the way through the courts, went through the Labour Tribunal, then went through the High Court, Hong Kong Court of Appeal, and finally the Privy Council. And in the end, in Li Ting Sang, the court found that the worker was indeed an employee. And that was important to him because then he could claim compensation under the Employees' Compensation Ordinance. So that's the second must-know case, Li Ting Sang, Privy Council. And you remember the result in Li Ting Sang because in the end, the worker was declared to be an employee, so he was happily. So it ended happily. Okay, so there you are. By contrast, Cheng Yun and the Royal Hong Kong Golf Club, which is now just the Hong Kong Golf Club, mentioned on page 19 of your course manual. In Cheng Yun, a golf caddy, 82 years old, my goodness me. So he sued the golf club and his claim was that he was an employee. And he won in the Labour Tribunal and the High Court, but lost in the Court of Appeal and the Privy Council. So the Privy Council finally in Cheng Yun found that the worker was indeed an independent contractor, IC, independent contractor. Okay. So the three cases there, and you've just about covered everything with regard to this issue. Is the worker an employee or independent contractor? That's all you need to know, and of course, by all means, read the other cases in your course manual. But as far as you're concerned, and the must-know part of the course, everything that's on the screen is must-know, and that's pretty well it. Okay. So market investigations, very important case because that does give us the test. And as market investigations is mentioned in your course manual on page 18. All right, so get out your colour highlighter for your must-know cases, whatever your favourite colour is, and colour in those cases. All right, so that's the first issue with regard to vicarious liability. Is the worker an employee or independent contractor? The test is in market investigations. Is the worker in business on his own account? If he is, then he's an independent contractor. If not, he's an employee. And it depends on the facts of the case. And the results go both ways. And look at Li Ting saying, I mean, he finally won all the way in the Privy Council. But Cheng Ying is, a very instructive case because the worker won in 2 of the courts and lost in 2 of the others. So, this is a very uncertain result when you go to court. Okay. So maybe you should have it spelled out. You should have a written employment contract. That would make it easier for the court to find that you are indeed an employee. Okay, so next big issue is if the worker is an employee, is he in the course of employment? And all the cases on the screen, everybody, none of them is must know. They're all sort of interesting historical cases. But I mean, they're sort of instructive. For example, Young Conqueror, I like. Young Conqueror is not in your course manual, but I like the facts because it was a car jockey, a valet. And remember, his job was to park the cars of customers who are coming to dine out in a restaurant. And he took the customer's car, was involved in an accident, so he was negligent. And so was the restaurant vicariously liable? And so the issue was, well, was the car jockey in the course of employment? And of course, the restaurant would argue, hang on, he was not in the course of employment because he had his girlfriend with him in the car. Surely that's taken him outside the course of employment. But the court said, no, 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 she was actually helping him find a parking place. She was assisting him in his job. And so they found that in Young Conqueror, the car jockey was still in the course of employment. Therefore, the employer was vicariously liable. Okay. The other cases, again, the last 2 are not in your course manual, but again, no real importance attached to those. Rose and Plenty, Story and Ashton, they are quite often mentioned in textbooks. Story and Ashton is in your course manual on page 28. Rose and Plenty is a good one. I like the case name, Rose and Plenty, because we're coming up to Chinese New Year. Plenty of roses coming out. Oh my goodness. Okay. And then in Rose and Plenty, it was, so I think it was delivering milk. So he gave a friend a lift in his milk cart, and the friend was actually helping him deliver the milk. And the court said that he was in the course of employment because what happened was that the employee was in a traffic accident. He was negligent. So it was the employer vicariously liable. The court said yes, he was still in the course of employment. So they all sound well and good, but everybody not must know any of those. They're all should know. This one, again, sort of interesting, but again, just something out of a movie, isn't it? Driver of a petrol lorry discarded a lighted match, bang, everything goes up. It's like a Jason Statham movie, or Sylvester Stallone, everybody sort of walks away and everything in the background's on fire. Okay. So I don't know, I'll just throw that one in. The only 2 must-know cases here, everybody, with regard to the issue, is the employee in the course of employment, Lister and Hesley Hall, and Ming An Insurance and Ritz-Carlton. Lister and Hesley Hall is the leading English case on in this area, and in Lister and Hesley Hall, the court laid down the so-called close connection test. Now, in Lister and Hesley Hall, The tort that was committed by the employee was the tort of battery. Now, on our course, we study negligence and we study private and public nuisance, but we don't study any other torts. And there are lots of other torts, as we covered when in the introductory lecture last time. So with regard to trespass to the person, there are three torts. There's assault, battery, and false imprisonment. Assault is you threaten somebody with immediate and unlawful personal violence. Battery is when you actually hit somebody, and then false imprisonment is, stopping somebody, impinging on their freedom. Okay. So battery is a tort, and what happened here is that the warden was guilty of rather nasty, well, it's a crime as well as a tort, of abusing boys under his care. All right. So the question was, though, he was doing this at night time. So was this in the course of employment? Now, under previous law, the Hesley Hall, the employer, would argue, hang on, he's not in the course of employment because he's outside normal working hours. But the court said, no, we will apply this close connection test. And the question that they will ask is on the screen, is the employee's tort, whatever it is, could be negligence, could be battery, any tort, so closely connected with the employment that it is fair and just to hold the employer liable. Must know the close connection test. Say again, is the employee's tort so closely connected with the employment that it is fair and just to hold the employer liable? That is the close connection test. And yes, must know. And of course, you will notice that there are two very vague words there, fair and just. Who decides what is fair and just? Good question. The judge in a particular case. So this is an example of the courts wanting to get more involved here and take control of these cases, because I think the public response to this particular case was rather strong. Abusing young boys, is an abhorrent crime and tort. And so I think the court said, we think that the employer should be vicariously liable, and so we will come up with this test. And of course, we decide what is fair and we decide what is just. And on applying that test in Mr. and Hesley Hall, the court found that the close connection test was satisfied, so it was fair and just to hold the employer liable. And the employer was Hesley Hall, which I think is a school. Okay, so there you are. That's the close connection test. And the law is reasonably recent on this. You'll notice it's 2001. All the previous cases on the previous one, you notice, are all before the year 2000. So they're all interesting, but they're all history. Okay, Lister and Hesley Hall is the leading case on the issue, is the employee in the course of employment. Okay, so that's the leading English authority, and it's been followed by the Court of a Final Appeal in the Mingan Insurance and Ritz-Carlton case. Okay, and I've got this PowerPoint on this one. So what are the facts of Mingan and Ritz-Carlton? Mingan and Ritz-Carlton, well, Lister and Hesley Hall is mentioned on page 25 of your course manual. Mingan Insurance is mentioned on page 26. Okay, so Court of Final Appeal, all right, and reasonably recent. And the Court of Final Appeal decision was made after Lister and Hesley Hall was decided. It's interesting, in the Hong Kong Court of Appeal, they didn't apply the close connection test because it had not even been invented yet, if you like, or decided. So in 2002, the Court of Final Appeal was considering this particular case, and they applied the close connection test. The leading judgment was by Mr. Justice Bakari, PJ, as he was then. He's now an NPJ, no pajamas. So, but he's recognised as one of the most liberal judges on the Court of Final Appeal, and he gave the leading judgment. Interesting one. So what were the facts of Mingan and Ritz-Carlton? He was a car driver, and he worked for the Ritz-Carlton Hotel, He was driving the hotel car, wearing the hotel uniform, and he didn't like the hotel food, or maybe because he couldn't afford it. So he was driving the hotel car, wearing the hotel uniform, and he was going out for lunch. I'm not sure where he went, maybe to get his favourite dim sum somewhere. I remember when I was in Happy Valley, they have all these lovely dim sum shops and all the celebrities would pull up in their cars and get their takeaway dim sum. Anyway, he went out for lunch and he was involved in an accident. He was negligent, okay? So, was he in the course of employment? Well, the court applied the close connection test. Was the employee's tort, his negligence, so closely connected with the employment that it was fair and just to hold the employer liable, the employer being Ritz-Carlton? And the court said, yes, it was fair and just to hold the employer liable. So what were the factors that the court took into account to decide that the close connection test was satisfied in Ming An? Well, as I mentioned before, the employee was wearing uniform and driving the hotel car. And here's an interesting bit. I mean, this is a Bakari point. The hotel had an interest in making sure that he was well fed. Ta-da! Well fed. Okay, and then that my comment in brackets, just sort of a throwaway line, didn't like the hotel food. I don't know. So there you are. Interesting case, Ming An and Ritz-Carlton. So next time you see somebody wearing a uniform and driving a car, tell them to be careful and just say, you know, well, did you know that your employer has an interest in making sure you are well fed? I don't know, actually. If you're well fed, you're more likely to have an accident because you're sleepy. Anyway, that's the decision of the court. And that's it. Court of Final Appeal, the highest court in Hong Kong, and the close connection test applies in Hong Kong. Okay, so when it comes to the issue, is the employee in the course of employment? There are just two cases, everybody, so that makes it easy. Lister and Hesley Hall gives us the test. Is the employee's tort so closely connected with the employment that it's fair and just to hold the employer liable? In Lister and Hesley Hall, it was the tort of battery. In Ming An, it was the tort of negligence, okay? And in both Lister and Hesley Hall in Ming An, the court found that the close connection test was satisfied, so the employer was liable in both cases, all right? And indeed, he was an employee. In both cases, the worker was an employee. That was not really an issue. Okay, so there you are, everybody. So going back, just to quickly wrap up vicarious liability and touch on the important points. The relationship we focus on here, everybody, is the employer-employee relationship. But bear in mind, vicarious liability can arise in other relationships. And in the employer-employee relationship, must know, must know, must know. This is your first must know definition on the tort part of the course. The employer is liable for damage caused by the torts of his employees acting in the course of employment. Remember, it is a form of strict liability. The employer is liable without being at fault. Okay, and the main justification for it fits in with the main aim of tort law, which is compensation. The employer is a much better target to sue usually than the employee because the employer has access to insurance. Also, the justification for vicarious liability is that the employer profits from the activities of employees. They should also bear any losses caused by the activities of the employees. So how do you know whether a worker is an employee or independent contractor? Apply the market investigations test. Is the person in business on his own account? And Li Ting saying the court finally in the Privy Council did decide he was an employee. Opposite conclusion in Cheng Yun and the Royal Hong Kong Golf Club. Okay, and then the other big issue we've just covered is the worker in the course of employment. All of these cases, everybody, are history, sort of interesting, but the only must-know cases will be, where are they? Yeah. Lister and Hesley Hall, Ming An and Ritz-Carlton. Okay, so that's vicarious liability, everybody. That's all that must-know bit. I've got a final paragraph, a final PowerPoint here, which is all should know, not must know. What about is an employer liable for independent contractors? Okay, well, this is should know, not must know. Normally, the employer is not liable for independent contractors because they are independent. Okay, but there can be exceptions, and there's some cases in your course manual which discuss this, but generally the employer would not be liable. In the Woodland case on page 30, the court did find that the employer was vicariously liable, but that's exception. It's normally the employer would not be liable for independent contract. Normally only liable for employees, okay, and who are in the course of employment. Okay, everybody, so that's vicarious liability. Now we're going to get on to negligence and the duty of care. So I just want to make this bigger. Hang on, how come that? Oh dear, come back. Sorry, I'm just fiddling around with my PowerPoints here, see if I can get them going a bit more. Okay. All right. Okay, not you. I'll do this again. Okay. And I've got to make it. There, that's better. Okay, sorry about that. Always takes a bit of fiddling around to get this. Okay, I've got that. Come back. I don't want you, I want the other one. Okay. Okay. Oh, sorry, I haven't got. Uh, I think we'll have a short break while I sort out my PowerPoints here. Okay, just a few minutes. Okay, welcome back, everybody. Sorry about that break. Slight technical problems, changing PowerPoint. I'm in room 205 today. I've just got one computer. It's a little one and it seems to run differently from others. Anyway, no excuses. Get on with it. Okay, so we're talking now about negligence. And what is negligence? Well, we're going to look at the elements first. I mentioned, first of all, the limitation periods with regard to negligence, because it's worth noting that the limitation period for tort actions in general is 6 years. Worth noting, you could almost argue it's sort of a defence. If somebody sues you for negligence, then you could say, well, I think it's been more than 6 years since the accident happened. Okay, unless it's personal injury action, the limitation period for personal injury action is only 3 years, but the courts are very generous in giving extensions of time. If you, for example, you're injured in a traffic accident, you don't know whether you're injured, well, injured or not, because it might be a latent injury, a hidden injury, then the court can extend the time so that you still have a chance to take action. All right, so what about negligence? The elements of negligence, everybody must know a sort of definition. I've sort of spread it out a little bit, but you can summarize negligence by saying that a duty of care, it's almost A, B, C, and D. A duty of care must be owed by the defendant to the plaintiff. Okay, and by the way, it's O-W-E-D, not O-W-N-E-D. Okay, and then there must be breach of the duty, and that depends on the standard of care, causing damage. Okay, so I mean, perhaps I should switch my third and fourth bullet points around. But if you want an easy way of remembering the elements of negligence, not that it's that difficult, A, B, C, and D. A, duty of care owed by the defendant to the plaintiff. Breach of the duty, that's the B, causing damage. Okay, so we will be focusing on the first element, the duty of care. Okay, and we'll be dealing with duty of care in its entirety. As I say, your course manual covers duty of care in both chapters 2 and 3, but I thought it makes sense to deal with duty of care, a whole lot of duty of care first, and then get on to breach. So that's why we're going to deal with 2.1 first on duty of care, and then we're going to, having covered duty of care first under 2.1 and 2.2, we're going to skip the rest of chapter 2 and jump to chapter 3 and deal with duty of care in certain special circumstances, namely where the plaintiff has suffered either nervous shock or pure economic loss. And when it comes to the issue of duty of care, always note what type of damage has been suffered by the plaintiff, because that raises definite distinct issues. Okay, all right, so we're looking at duty of care and a little bit of history here. First of all, duty of care before Donoghue and Stevenson, DNS, Donoghue and Stevenson. I've already mentioned Donoghue and Stevenson briefly. Remember when we dealt with the topic in contract law of privity of contract, that only parties to a contract can sue or be sued. That's the general principle of privity of contract. And in Donoghue and Stevenson, Mrs. Donoghue bought a bottle, she drank from a bottle which was an opaque bottle which had a decomposed snail in it, and she got gastroenteritis. Could she sue for breach of contract? No, because she was not a party to the contract. So she took action in the tort of negligence. But before Donoghue and Stevenson, the law was against Mrs. Donoghue because a duty of care, DOC, was owed only in certain fixed relationships. And they are mentioned in your course manual on page 33. And they're on the screen. Employer-employee, ta-da, okay, which we've already looked at. Occupier-visitor, okay. So I'm in the Hong Kong U lecture room 205 tonight. So if I get electrocuted by fiddling around with this computer, I can sue the university, perhaps in what we call common law negligence, I can also, by the way, sue them in the other tort of occupier's liability, because the university owes a duty of care to all visitors. All right. Also, carrier passenger. None of you will be travelling tonight. I will be. But the MTR owes me a duty of care when I'm travelling on it. Okay. Please, I will mind the gap. Absolutely. Doctor-patient. Yes. Clearly a duty of care, literally owed by a doctor to a patient. And then finally, similar to occupier visitor, innkeeper and lodger. So if you manage to get away on a holiday somewhere and you're a lodger staying in a hotel, the hotel will owe you a duty of care. But they were the only relationships in which a duty of care was owed. So along comes Donahue and Stevenson in 1932, the famous snail in the bottle case. And Mrs. Donahue got gastroenteritis, and so she sued the manufacturer. But she was not party to the contract because she didn't buy the bottle herself. So there was no privity of contract in Donahue and Stevenson. But Lord Atkin comes up with that very famous passage, you must take reasonable care to avoid acts or omissions which you can reasonably foresee. So I've highlighted those two words, reasonably foresee, would be likely to injure your neighbour. Now, who is your neighbour? And this gives us a second element of what we call proximity. A neighbour is a person who is so closely and directly affected by my act that I ought reasonably to have them in contemplation as being affected by my act when I'm directing my mind to the acts or omissions which are called in question. Don't worry, you don't need to know that quotation off by heart, but you do need to appreciate what law has been laid down here, and it's the two elements of reasonable foreseeability and proximity. And so if those two elements are satisfied, a duty of care will be owed. And the result of Donahue and Stevenson, everybody, is to open so-called floodgates to lots of cases. Before Donahue and Stevenson, there were relatively few negligence cases. After Donahue and Stevenson, many more cases because of these two elements introduced by Lord Atkin of reasonable foreseeability and proximity. Proximity comes from the neighbour principle. And so what do you mean by proximity? Somebody who's so closely, closeness means proximity. Okay? So watch out for the terminology here. Generally, the terminology is quite vague, because what do you mean by reasonable foreseeability? It's a very vague term. And what do you mean by proximity? How close is close? Okay, good question. And the bottom line here, everybody, is that it's going to be up to the court to decide whether a duty of care is owed, because the court will decide what is reasonable, foreseeable, and also they will decide the appropriate degree of proximity. So the judges, if you like, have taken the law into their hands, and they will say that a duty of care will be owed, not just in those fixed relationships we looked at before. Where are they? These ones. They will also, a duty of care will also be owed any time you can establish these two elements of reasonable foreseeability and proximity. Okay, so true to say, Donahue and Stevenson has changed the law in a big way, and it is generally and universally applicable both in England and Hong Kong. Also, it applies not just to personal injury actions, it applies to property damage, okay, and must-know case. So add Donahue and Stevenson to your list of must-know cases. One of the most famous cases in tort law, not just negligence law. All right, so how have the courts applied the elements from Donahue and Stevenson? Good question. After 1932, we have four elements which the courts will look at to decide whether a duty of care is owed by the defendant to the plaintiff. The first two, of course, come from Donoghue and Stevenson. But these are very broad factors, and a duty of care will be imposed in a far greater range of situations than before. So the courts have introduced two other elements, justice and reasonableness and policy arguments, to restrict the application of the duty of care. Okay? But again, what do you mean by justice? What do you mean by reasonableness? And what policy? Who decides the policy? Okay, well, policy really turns on who is the defendant. So if the defendant is some sort of public body, the courts are usually reluctant to impose a duty of care on a public body such as the police. And we'll look at a famous case of Hill and the Chief Constable of Yorkshire shortly, which is probably the leading case on the element of policy or public policy. Okay, don't sort of get carried away, everybody. This is not a mathematically exact formula to apply. These definitions are very vague, and there's considerable overlap between them. Basically, it's going to be up to the court in a particular case to decide whether or not a duty of care is owed, and the courts have lots of flexibility because they are the ones who decide what these vague definitions mean. Okay, so I mean, it does sort of help. Then we're going to go through these elements in a moment. So let's have a look at some cases applying, if you like, the formula for duty of care after Donoghue and Stevenson. Probably the most important case, well, certainly a case that's reasonably easy to understand, is Home Office and Dorset Yacht, which is on page 35 of your course manual. In Home Office and Dorset Yacht, there were Borstal boys. What's a Borstal boy? You know, young offenders. And they were taken to an island as part of their rehabilitation. And of course, they're young criminals, for want of a better word. And so, you know, nobody likes to be locked up. So they're on an island. Now, if you're a young prisoner and you're on an island and you want to get off, well, you could try swimming, yes, but that's not very advisable, particularly if there are sharks around or anything. So what they decided to do was steal a boat so they could escape from the island. Now, where do you find a boat? Well, there's the Dorset Yacht Company, Dorset Yacht Club. So let's go and steal one of their boats. So that's exactly what they did, and they damaged one of the boats belonging to the Dorset Yacht Club. And so the Dorset Yacht Club sued the Home Office, and then it went all the way to the House of Lords, and the issue was a duty of care owed by the defendant to the plaintiff? And the court said yes, it was, because it was reasonably foreseeable that a young prisoner on an island would want to get off the island, and of course it was proximate, it was close by the yacht club, and so those first two elements of reasonable foreseeability and proximity were satisfied. Therefore, almost QED, the court found in the Dorset Yacht case that a duty of care was owed. Okay, so this is the courts applying the Donoghue and Stevenson formula pretty closely, right? And then along comes Annes and Merton. Annes and Merton is a problematic case dealing with buildings, and it's a House of Lords case. Said the court said a duty of care was owed if you have a property which is in a poor state of repair, likely to fall down. Now, nobody's been injured yet. This is the important thing about this. And the court seemed to apply the Donoghue and Stevenson formula very liberally in the Annes and Merton case. And they say, well, reasonable foreseeability, proximity, bingo, duty of care. But Annes and Merton has been disproved by later cases, particularly Murphy. So when it comes to buildings in a rundown state of repair, there will not be a duty of care owed unless there is direct personal injury or property damage. Okay, and in Annes and Merton, the building hadn't fallen down yet. Nobody had been injured. No property had actually been damaged, and so that everybody thinks Anns and Merton's wrongly decided, and indeed the House of Lords and Murphy disapproved of the Anns and Merton case. Now, these cases on the screen, everybody, look a bit complicated, yes, but don't worry, we're going to wrap all this up in a very good PowerPoint at the end. And you'll notice the important point here is what type of damage has been suffered by the plaintiff. If it's direct personal injury or property damage, the courts are more willing to impose a duty of care, okay, because of proximity considerations. If there's direct personal injury, obviously there's sufficient proximity or closeness. And normally, of course, that would reasonable foreseeability would also be satisfied. Okay, so Home Office and Dorset Yacht, Anns and Merton, House of Lords cases seem to apply the Donoghue and Stevenson formula pretty liberally, but everybody, particularly the Anns and Merton case, everybody thinks that was wrongly decided. And so later cases like Yuen Kun Yu, which is a Hong Kong case, Yuen Kun Yu on page 37, the court found that there was no duty of care owed by the Commissioner for Deposit-Taking Companies when an investor lost all of his money. And the investor sued the Commissioner of Deposit-Taking Companies because he said, you registered this company, therefore, Commissioner, and you've got a register of all these companies under the Deposit-Taking Companies Ordinance. And so the investor thought that the Commissioner was negligent. But the Privy Council dismissed this and said there was no duty of care owed. They took advantage of this case to reformulate the test for determining whether there is a duty of care. And it simply said there was insufficient basis for finding a duty of care. Why is this? Because the Commissioner can't sort of go and check on the financial viability of every company that has been registered. They simply don't have the resources to do it. So it's almost a policy decision to not impose a duty of care on the Commissioner for Deposit-Taking Companies. Okay, so the court said that even though it might be reasonably foreseeable that there might be losses suffered by the investor, that was not sufficient. Okay, you do need this extra element of proximity, and there was not sufficient proximity in the Yuen Kun Yu case. Also, the Murphy case is another one which we're going to look at later. Murphy overruled the Anns case and said there's no duty of care where you've got buildings which are in a, have sort of latent defects. So there'd be no duty of care owed for latent defects unless the building actually did collapse and cause personal injury or property damage. Obviously, then you've got the sufficient proximity. Also, an instructive case is Caparo. Caparo on page 36 says, well, hang on, what's going on here? We start off Donoghue and Stevenson, which seems to expand very greatly the situations in which a duty of care will be owed. There's two elements of reasonable foreseeability and proximity, particularly reasonable foreseeability. And so cases since then have started to, the courts have pulled back a little bit. And Caparo and Dickman is a good case on page 36. The court said, hang on, let's not go overboard with finding a duty of care in too wide a circumstances. So they will say there will be a duty of care owed if there is reasonable foreseeability of loss and damage by the defendant, plus a sufficient relationship of proximity. So this element of proximity is thrown in to limit situations in which a duty of care is owed. And then they also throw in this third element of whether it is just and reasonable in the circumstances to impose liability. Okay, so justice and reasonableness. So that's a third element that the courts have come up with, and this third element of justice and reasonableness laid down in Caparo is a limiting factor. The courts, and the case that deals with that is a case called Mark Rich, which we'll come to in a moment. So with regard to reasonable foreseeability and proximity, are they two separate elements? Not really. They do overlap, and so they're very vague. Okay, proximity, if you like, limits the application of the duty of care. There's got to be sufficient proximity. Okay, but in Home Office and Dorset Yacht, the courts were pretty generous. They said that we will apply Donoghue and Stevenson unless there's some valid explanation not to do it. In other words, it's really up to the courts. So this is why a lot of these cases, you know, some look pretty liberal, others look more restrictive. Okay. Okay, so that's the Home Office and Dorset Yacht case, which did seem to apply Donoghue and Stevenson pretty directly. But then along comes Paparo, which gives us this extra requirement that there will not be a duty of care unless it's fair, just, and reasonable. Again, very vague expressions, okay, and very open-ended meaning. Okay, and in the case of Mark Rich and the Bishop Rock Marine, which is on page 40, this concerned cargo which was on board a ship, but it was loosely tied down and there was a bit of a storm and the cargo got washed overboard. Was a duty of care owed by the owners of the ship to the owners of the cargo? Well, was it reasonably foreseeable that the cargo could be washed overboard? Yes, but was there sufficient proximity? The court said no, and they said, well, this has not directly caused property damage. This is indirectly caused property damage. But then again, where do you draw the line between direct or indirect physical loss? And couldn't you argue in Mark Rich that if you lose cargo overboard on a ship, that looks like pretty direct physical loss? The court said no, it was indirect. So it's the courts saying, well, we don't think a duty of care should be owed in this case, like Mark Rich, and also in the Hong Kong case of Alcatel Cable. And the Alcatel Cable case is also on page 40. And so the court's saying, well, we don't think a duty of care should be owed, so how are we going to justify it? Well, we'll simply say it's not fair, just, or reasonable. Okay, so everybody says, well, what is this category? I mean, fair, just, and reasonable. You got just about three very vague words. I think one possible explanation of why there was no duty of care in either of the cases on the screen is the fact that the parties involved could sue for breach of contract. So the court said, well, if you want to claim for the loss of your cargo, you can always sue for breach of contract. So why do you need to be able to also sue in the tort of negligence? Okay, so that's the court's trying to justify this. So it's rarely available, a duty of care in these circumstances where there is also a breach of contract. But again, it's very vague. The courts really, they want to justify not imposing a duty of care. They can always say it's not reasonable. But does this add anything to the other factors? Okay, because good question. And then we come along to the last element here, and this is the element of policy. This is perhaps a little bit more easier to understand, is that the courts are reluctant to impose a duty of care where the defendant is a public body or a public authority. Now, I've got some cases on the screen which are not in the course manual, but so should know, not must know. Stoven and Wise, simply a local authority dealing with barriers at a road intersection, and there was an accident, so they were sued. The court said no duty of care because it involved a local authority, the local council. Also, in these COVID-19 days, there's another case there called Clunas, in which the court found that the health authority did not owe a duty of care, and also the education authority did not owe a duty of care, except in the Phelps case, in which it was very, very rare, in which they could find a duty of care. But normally, if you're a public authority, you will not owe a duty of care, so you cannot be sued for negligence. And in Yun Kun Yu, you could argue that the Commission of Deposit-Taking Companies was a public authority, and so the courts are reluctant to find a duty of care owed in these circumstances by the commissioner to ordinary shareholders. Okay, so generally, if the defendant's a public authority, there will not be a duty of care owed. Okay, and probably the most interesting cases in this area are the ones involving the police. Okay, so we're going to look at some interesting cases here with regard to the police, but and particularly the Hill case is quite an important case. So we need to go through that in a little bit of detail. The facts are quite interesting, but I think because it's going to take a little bit of time to go through Hill, probably a good time to have a short 10-minute break. I'm going to get some hot chocolate. So we'll have a short break. Okay, welcome back, everybody. Hope you had a good drink. I've got some nice hot chocolate here, which should keep me warm. It's actually cool in here with the air conditioning. Oh dear. So before the break, we're looking at duty of care and circumstances in which it will be owed. And sort of just to recap a little bit, if you go back to Donoghue and Stevenson, remember before Donoghue and Stevenson, duty of care was only owed in certain fixed relationships. But then along comes Donoghue and Stevenson and gives us particularly the element of reasonable foreseeability. Now, reasonable foreseeability is pretty wide, okay? I mean, you can reasonably foresee things happening. In other words, we haven't got a crystal ball, but we can sort of reasonably foresee things might go wrong. There's actually an interesting case in your course manual on page 38 called Chang and Lai concerning a dog which was normally tame and kept on a leash. But then they had a party in the property, and the one of the children was invited to some sort of birthday party. And then one of the children tried to feed a dog a biscuit, but then the dog suddenly got violent and bit the child on the face. So was a duty of care owed to the child? And the court did find yes, even though the dog was a tame dog, it was reasonably foreseeable that, you know, in certain circumstances, particularly when you've got a party going on, lots of noise around, that the dog might become more aggressive, okay? And the court did find that because it was reasonably foreseeable that the dog might bite somebody, then that was sufficient to impose a duty of care. So, and certainly there was proximity. It was directly caused personal injury. That's actually an important factor we'll look at when it comes to duty of care in a moment, okay? So reasonable foreseeability. The problem with reasonable foreseeability, though, it's very vague, isn't it? I mean, reasonably foresee things going wrong? I don't know. Okay. And then, of course, proximity is some sort of restrictive factor when it comes to reasonably foreseeability, although they do overlap, because you can reasonably foresee things which are close to you, you know, things might happen. So if you were in class at the moment with me, I always say if I throw a bottle, an empty bottle, into the classroom, it's reasonably foreseeable that I'll hit somebody because you are close. There is proximity or nearness, okay? But as I say, these cases sort of go backwards and forwards, and the reason is because all of these elements on the screen are very vague, and it really is up to the court in a particular case to decide whether a duty of care should be owed or not, particularly this element of justice and reasonableness. Okay. So you might say, oh, hang on, sounds a bit complicated, all of these cases. Yes, but we're going to tie this all together shortly, and we tie it all together by looking at the type of damage suffered by the plaintiff. And once you know what the type of damage is, then whether the question of duty of care becomes much clearer. Okay. All right. So how wide is reasonable foreseeability? Good question. The cases, some cases go further than others. Home Office and Dorset Yacht sounds a reasonable decision, though. It's reasonably foreseeable that boys would want to get off an island, and there is sufficient proximity, namely the yacht club. So everybody thinks Home Office and Dorset Yacht is a reasonable application of reasonable foreseeability, and there was sufficient proximity in Home Office and Dorset Yacht. But Anns and Merton has been overturned by Murphy with regard to defective buildings. Okay, so a defective building, nothing's happened. If you like, it's possible to fall down, but hasn't fallen down yet. In that case, no duty of care would be owed just yet. But if the building does collapse, causing death or personal injury or property damage, fine. So then a duty of care will be owed. Okay, so that's perhaps helpful. And then Caparo sort of tries to tie all this together by saying, well, we know about Donoghue and Stevenson, but let's be careful. We'll only extend the situations in which the duty of care is owed. We'll do it step by step, the so-called incremental approach to duty of care. Okay? But then we have the other factors. Apart from proximity, we also have fairness, justice, and reasonableness. And this normally applies where the plaintiff has another cause of action, typically breach of contract. So the courts are saying, well, you can always sue in breach of contract, so there's no need to impose a duty of care. Okay. And so you can see the court, particularly in Mark Rich, in which losing cargo overboard on a ship, the court said was not directly caused property damage. If it was directly caused property damage, then there would be a duty of care owed. But they say losing cargo overboard on a ship was indirectly caused physical loss. But everybody's thinking, hang on, they're scratching their heads and say, well, what's the difference now? If I lose cargo off a ship, seems like pretty direct damage to me. All right. And then we come along to the situation where the courts will apply public policy, and if the defendant is a public authority, generally there will be no duty of care imposed, simply because there are too many possible people who could sue the public authority. I mean, thousands of people, okay? So if that's the case, the public authorities wouldn't be able to do their job, or they would do their job in such a, restrictive manner because they'd be too scared to do anything in case they got sued for negligence. Okay, so cases which are not in your course manual but do illustrate the fact that the courts are reluctant to impose a duty of care on public authorities, Stoven and Wise, Clunas and Phelps, and then Yun Kun Yu is a good case. Clearly the Commissioner for Deposit-Taking Companies, if he owed a duty of care to every person who invested in a deposit-taking company, he would spend all his life for defending cases. So no duty of care was owed in the Yun Kun Yu case, simply because, too many people, if you like, and it's impossible for the Commissioner for Deposit-Taking Companies to keep a close eye on the financial standing of every company that was registered under the Deposit-Taking Companies ordinance. By the way, deposit-taking companies were big in the 1980s in Hong Kong. I actually invested in one of them. I mean, they offered really generous returns. Put your money down for 3 months and you'll get 25 or 26% interest. My goodness. I actually did that once or twice. I did get my interest back and I said, this is too good to be true. And it was. And of course, a lot of buildings went bust. And this is where Yun Kun Yu comes in, because he was one of the persons who was sort of caught out when the company involved went bust. It's a bit like this good sport run in the stock market in America at the moment. And of course now they're trying to boost the price of silver. I mean, people do lose money when they invest in these sorts of financial enterprises. Okay. And then with regard to the police, so this is where we got to before the break. Some interesting cases here, particularly the Hill case. And I'm just checking my notes. Hill is on page 43 of the course manual, and it was a notorious case because it involved the Yorkshire Ripper. Now, the Yorkshire Ripper was a serial murderer, and he was responsible for a number of murders in the Yorkshire area. Mrs. Hill's daughter was one of the victims of the Yorkshire Ripper, and so her mother sued the police. But did the police owe Mrs. Hill's daughter a duty of care? Okay, well, the decision was no. The court said in some instances the imposition of liability may lead to the exercise of a function being carried out in a detrimentally defensive frame of mind, which means what? It means that the police be too scared to do anything, and so they'd spend all their time just sitting around in their police station and not doing anything. And of course we want them to be a little bit more proactive. Okay, and so there was no duty of care held in the Hill case. Of course, Mrs. Hill was not happy with this. I would say, hang on, you knew there was a serial killer on the loose around this area and he was targeting young ladies, and surely there's proximity here, reasonable foreseeability. And my daughter was, in that category, and you should have looked after her. But the police said, well, hang on, sort of matter of logistics here. We can't sort of have every young lady in the Yorkshire area accompanied by 2 constables wherever they go. It was simply not possible logistically to protect every young lady in that Yorkshire area, okay? And also the other reason, which is on the screen, the police would be too defensive. They wouldn't want to do anything for fear of being sued in negligence, okay? So how you justify this, you could justify it's a matter of policy. You could also justify that it would not be just and reasonable to impose a duty of care in these circumstances. Because, what is fair, just and reasonable will depend on the facts of each case. And normally the courts are reluctant to impose a duty of care on any public authority, particularly the police. And this is borne out by later cases, such as in the Brooks case on page 44. And in the Brooks case, they followed the Hills case. And you notice the year, Hill is 1989, Brooks is a bit more recent, 2005, where Lord Stein's statement that, that basically they say, well, we'll follow Hill and that there'll be no duty of care. The courts, they're generally reluctant to impose such a duty of care. Again, for main reasons, lack of manpower, and also to make sure that the public authority can do their jobs without fear of being sued for negligence. However, there is some argument saying that in certain circumstances, a duty of care would be justified in circumstances where, if you like, the person who was targeted by whoever the wrongdoer is so well known for the police that, they should have taken extra steps to look after him. So Smith case on page 45 sort of opens the door slightly to the court's finding that there is a duty of care. You've got the facts there on page 45. The claimant Smith was receiving up to 15 abusive text messages a day. They're in the 2000, slightly before 2008. Smith, smartphones were just coming in. I guess they had texting in 2008. I have to check my diary. Anyway, so it said, "I'm looking to kill you and no compromises." And although Smith had repeatedly complained to the police and had shown the police the threatening messages, the police failed to take any action, and then he was indeed attacked with a claw hammer, causing serious injuries. So everybody said, well, hang on, it's not like Hill. In Hill, they didn't know who the Yorkshire Ripper was, number one. Number two, there were lots of ladies at risk, so you couldn't have a policeman with every young lady. But it's different in the Smith case because there was only one person at risk, and they knew roughly who the other person was. So Smith is a case that almost cries out for a duty of care being imposed, but the courts are very reluctant to find that a duty of care will be imposed on the police. So the bottom line is that if there's going to be duty of care owed by police, then it would have to be in the form of legislation, and that certainly hasn't come forth yet. Okay, so the police are in an interesting position there. No duty of care usually owed by the police for lack of manpower reasons, and also you could argue lack of proximity because you don't know, who's going to strike when. And in the Yorkshire Ripper case, they didn't know who the Yorkshire Ripper was. They eventually found him, but well after Mrs. Hill's daughter was killed. Okay. So interesting case, serial killer case, the Yorkshire Ripper. Now, what about lawyers and duty of care? Well, lawyers generally certainly owe a duty of care to your clients, but what about judges and arbitrators? Normally they don't owe a duty of care. Also, court advocates, we're talking here about barristers, usually don't owe a duty of care, but immunity has been abolished in England, not yet in Hong Kong. If you're a barrister in a case, normally you don't owe a duty of care to your clients. Okay. With regard to solicitors, the courts are a little bit more willing to extend the duty of care to solicitors, and this is illustrated by the two cases of Ross and Quarters and White and Jones, both of which are on page 85. 85? 45. 45. Okay. Yeah. Maybe that is right. No. Yes, page 85. As I say, your course manual deals with duty of care in other situations. These two, Ross and Court is on page 85. Remember, your course manual deals also with duty of care in chapter 3. I don't know why. I mean, if I was doing this, I would deal with duty of care all in one go in one chapter. Okay. Oh, by the way, the second element when it comes to negligence is breach of the duty of care. Now, if you want an example of a good textbook on tort law in Hong Kong, there's one written by my former colleague at Hong Kong U, Rick Klofczewski, and he's got a book called Tort Law in Hong Kong. And I actually taught tort law when I was at Hong Kong U, and he was in charge of the course when I was there, and he wrote the book. And I said, well, why did you deal with breach first? What seemed more logical to deal with duty of care first? Well, he says, well, students find duty of care a little bit tricky. And of course, it's tricky because of all these vague words like reasonable, foreseeability, and proximity, etc. He says, I like dealing with breach because it's a bit more straightforward. Anyway, I just thought I'd mention that. So if you think, hang on, he's talking about duty of care. Sounds a little bit complicated. Yes, but not too bad. All right. But as I say, if I was writing a tort book, I would deal with duty of care all in one go. And so your course manual deals with duty of care both in chapter 2 and chapter 3. So these cases dealing with solicitors. The question is, does a solicitor owe duty of care to his clients? Yes, clearly that's not a problem. But in both Ross and Quarters and White and Jones, they concerned wills. And before these cases, a duty of care was owed by a solicitor to a client, but not to any beneficiary under a will that the client might make. And that was changed in Ross and Quarters. Okay, the defendant was the solicitor retained by a testator to draft a will. He negligently failed to warn the testator that a beneficiary and his or her spouse should not be the witness for the testator's will, or the gift to the beneficiary would lapse, is the word. The testator's will was witnessed by the husband and one of the beneficiaries, so the beneficiary sued the defendant for loss of the gift, and the court held that the solicitor owed the plaintiff beneficiary a duty of care and was liable for the loss. So Ross and Quarters, interesting case where you see tort law overlaps with succession and probate practice. In White and Jones, similar situation. It was a father who had two daughters. He made a will initially excluding the daughters because they had acted badly, but then they reconciled, and so the father gave instructions to the lawyer to prepare a new will, leaving £9,000 to each daughter. But the solicitor failed to prepare the will in a timely manner, and then the father died. So who were upset? The two daughters, because the will was not executed, giving them their gift under the will of £9,000 each. So was a duty of care owed to the daughters? And the courts followed Ross and Quarters and said, yes, a duty of care was owed to the beneficiaries of a will. Okay, so that's a good case. And then got another case on the screen, and this one is one I've thrown in. This is not in your course manual. Trend Publishing, decided by Mr. Justice Keith. Mr. Justice Keith, very good judge. I appeared in front of Mr. Justice Keith several times, and normally he agreed with me. The author's name, Rick Klofczewski. I'll write that down in the chat box. Rick loss, C-O-L-C-H-E-S-A-I. Yeah, it's Rick Klofczewski. Okay, good. Yeah, it's a good book. Okay, and he's the way Rick set out his book is very good. It's a relatively easy book to read. I mean, textbooks are notoriously difficult to read sometimes, but the way he sets out his book is pretty good. In fact, when I wrote my contract law book, I said to Mick Fisher when we were writing the book, let's make it student friendly. So if you read my contract book called Contract Law in Hong Kong, you'll find it student friendly. It's set out in such a way, it makes it easier to read, okay? So it's more student friendly, more reader friendly. And Rick Klofczewski's book is a good one. I think it's into about the 3rd edition now. Okay, so there you are. And certainly if you've got time, you can follow up on some of these cases. Now, here's a case I thought I'd throw in because I know Mr. Justice Keith is a good judge, and it's interesting because the court, this is where the court was asked to consider whether a duty of care was owed by solicitors of a landlord to a tenant in a lease agreement, and the court said no duty owed by the landlord to the tenant. Okay, that's just an interesting one. That just goes to show this issue of duty of care is alive and well, both in England and Hong Kong. So there you are. Solicitors, bad luck. There will be duty of care owed to beneficiaries under a will, okay, not just your client. If you're a barrister, you're probably not likely to be sued, but watch out, the law could change, okay. So that's lawyers. Rescue services. Now, if somebody is, in peril and you dive into water and you try and rescue somebody, what about a duty of care in these circumstances? Well, the courts usually say that if a rescue service is called to rescue somebody, will be treated like police, and there will be no duty of care owed to people who are going to rescue other persons. However, there may be circumstances in which which do allow the courts to consider imposing a duty of care. And so there are a couple of cases there, rescue services, I haven't got a page reference to, but again, normally the fire brigade comes to put out a fire, they will not owe a duty of care. But it's interesting, in the Kenton Griffiths case, the ambulance was late and the court found a duty of care was owed by an ambulance. Okay. Now, in Hong Kong, the ambulance service is very good. I've called the ambulance service a number of occasions and they get there really quickly. If you call the ambulance because there's some incident going, you'll have to make sure you're properly dressed and got all your papers together because they get there really quickly. Okay. So in certain circumstances, the ambulance may owe a duty of care. But normally no, because rescue service is a little bit like public authority. There is a little bit like immunity, if you like, because they're doing their job under emergency circumstances. And so it would be exceptional for a duty of care to be owed. But in those two cases on the screen, which are English ones, capital and counties, fire authority did increase the damage, so there was a duty of care owed. And then in Kent and Griffiths, the ambulance being late, the court found was a duty of care owed there as well. But usually no. There can be circumstances in which the duty of care is owed. All right, now I've thrown in Caparo and Dickman by way of sort of trying to draw all these little points together since Donoghue and Stevenson. Remember, Donoghue and Stevenson has given us these elements of reasonable foreseeability and proximity. And so in Caparo, the court say, well, a duty of care will be very slow at extending situations where a duty of care is owed, but we will have this sort of three-stage test. First of all, there's got to be reasonable foreseeability of damage or personal injury. There's got to be a sufficient proximity of a relationship, and it has to be fair, just, and reasonable to impose the duty. Again, very vague words. Fair, just, and reasonable. Well, who decides that? The court. So if the court thinks it's going to, a duty of care should be owed, then they'll impose it. Okay, so this is the so-called incremental approach to the duty of care, and the aim is to restrict the duty of care. It's a case on the screen called Ball, Hill and Young. We're going to deal with that case later on when we deal with nervous shock. Okay, but the important point to note, and we're going to look at this in a moment, if the plaintiff has suffered directly caused physical damage, whether it be personal injury or property damage, then reasonable foreseeability and proximity are exactly the same thing. Okay, so when it comes to the question of whether a duty of care is owed, look to see what type of damage has been suffered by the plaintiff, and that will determine go a long way to determining whether a duty of care is owed or not. So, sort of further on Caparo, just to finish off, certain categories will be protected, but the type of damage will determine the degree of protection. Okay. So that probably is a good time to come up to what you might call a summary or overview of everything we've covered so far on duty of care. And this also acts as a bridge to the next section we're going to deal with on duty of care, namely duty of care where the type of harm suffered by the plaintiff is either nervous shock or pure economic loss. Okay, everybody, so watch out for this. If you're in an exam question and you're asked to advise somebody on whether they can sue in the tort of negligence, what's the first thing you do? Tell the examiner you know all the elements of negligence, a duty of care owed by the defendant to the plaintiff, and then breach causing damage, which is not too remote. Okay, then you have to look to see which one of these elements of negligence is an issue. Duty of care normally is not an issue if the type of damage suffered by the plaintiff is directly caused personal injury or property damage. So this is what I call physical damage. So if it's directly caused physical damage, then normally a duty of care sort of follows automatically. Typically, a car driver will owe a duty of care to all other road users, including pedestrians, okay? And particularly where the type of damage suffered by other road users normally would be property damage and or personal injury, okay? So if somebody is injured in a traffic accident, then the relevant car driver will owe a duty of care automatically applying Donoghue and Stevenson, because it's reasonably foreseeable in those circumstances that if you suffer directly caused personal injury or property damage, then there's sufficient proximity, there will be a duty of care owed. Okay. However, where the type of damage suffered by the plaintiff is not directly caused personal injury or property damage, you do need to go into further analysis as to whether or not a duty of care is owed. And these other types or categories of harm will be either nervous shock or pure economic loss. Nervous shock or pure economic loss. What is nervous shock? Well, we'll look at this in a moment. It's a recognized mental illness, if you like. And nervous shock is sort of mirrors the fact that medical science has progressed over the last 100 years or so, particularly in the area of mental illness. Before, you couldn't claim any damages for so-called nervous shock. People say, well, you know, you're a tough person, get over it. But now people do recognize that people can suffer mental injury just as well as physical injury, and you can claim damages if you do suffer mental illness or nervous shock, a recognized psychiatric injury in certain circumstances. Okay, we'll look at that in a moment. And also, there is a duty of care owed by the defendant to the plaintiff when the plaintiff has suffered what we call pure economic loss. This is, they don't suffer personal injury, they don't suffer any property damage, they simply suffer financial loss. Pure economic loss is loss which is not the result of either personal injury or property damage. Okay, and we'll see that when we look at these cases later, that in order for a duty of care to be owed for both nervous shock and pure economic loss, the plaintiff has to show the extra element of proximity. Okay. However, if the damage caused to the plaintiff is directly caused personal injury or property damage, proximity is automatic. You don't need to show proximity. Okay, so I need to change the PowerPoint. So let's see if I can do it seamlessly. Aha, good, well done. Okay, so let's have a look here at a duty of care, whether it's owed for situations in which the damage suffered is not directly caused personal injury or property damage. It's either psychiatric harm or nervous shock or economic loss. Psychiatric means of the mind. Okay, your psyche, E-S-Y-C-H-E, means your mind. It's Greek for mind. Okay. First of all, quick review of the duty of care, which is what we've covered so far. All right. So remember, what is the duty of care? It's a relationship or connection between the defendant and the plaintiff that justifies the imposition of a legal responsibility for a failure to take reasonable care. Generally, you need the elements of foreseeability and proximity, and that's from Donoghue and Stevenson. You do need proximity as an additional requirement in cases like Dorset, Yacht, Ewan and Hill, okay? And then what about this other element of fairness, justice and reasonableness? Well, this is where the courts think the duty of care should not be owed because the plaintiff can sue for breach of contract. So that's the Alcatel, Mark Rich cases. And then also remember, the courts may not impose a duty of care for policy reasons. Okay, so that's a quick review. With regard to policy, just a quick reminder about the Hill case. In the Hill case, remember, the court said that the police would not owe a duty of care for public policy reasons because the police wouldn't be able to perform their duties. They'd be too scared to do anything because they would be distracted by the possibility of being sued for negligence. Okay. Also, with regard to whether a duty is owed by the police, they simply don't have sufficient resources, sufficient manpower to protect every member of the public. Okay, so that's just a review of the Hill case. And then with regard to duty of care, remember the factors, but remember all of these factors are very vague and there's overlap between them. And we're going to focus mainly on the first two in this particular section. And remember, the courts still have the other limiting factors of saying, well, if it's not just or reasonable, we will not impose a duty of care, or if the defendant is a public authority, we will not impose a duty of care. So when it comes to the issue of whether duty of care is owed or not, it normally boils down to foreseeability stroke proximity. But as I was saying before, if the damage suffered by the plaintiff is directly caused personal injury or property damage, proximity is presumed as part of foreseeability. So which factors apply? Not all the factors apply in every case. You have to look to see what type of damage has been suffered. Okay, and that's what we're talking about before. So everybody, directly caused personally physical damage or personal injury, then you simply apply Donoghue and Stevenson. So particularly with motor vehicle accidents, which come up regularly in exams, all car drivers owe a duty of care to all other road users, full stop, Donoghue and Stevenson, because foreseeability and proximity go together. And we're assuming, of course, that the plaintiff has suffered directly caused personal injury or property damage. Okay? So there you are, the neighbour principle, foreseeability is sufficient You simply need to show that the harm to the person is reasonably foreseeable if the defendant fails to take reasonable care. Okay, indirectly caused physical damage. Again, sort of reluctant to do this because remember Mark Rich and Alcatel, the cases in which the court's saying we don't think a duty of care should be owed, where the plaintiff can also sue for breach of contract. So we will say it's not fair, just, or reasonable to impose a duty of care. But they're sort of making it up, because remember in Mark Rich and Alcatel, cargo lost overboard on a ship. The court's saying, well, it's not directly caused property damage. And everybody thinks, hang on, this does seem to be the court's making it up. They don't want to show, find that there's a duty of care owed. Okay? And so they will come up with they can say it's not just, or there are policy reasons not to impose a duty of care. Okay, so what we've covered so far, everybody, with regard to duty of care is situations in which, as far as you're concerned in exam questions, look at the damage suffered by the plaintiff. If it's directly caused personal injury or property damage, a duty of care will be owed almost automatically because foreseeability and proximity are the same. It's directly caused, so obviously the proximity and closeness element is satisfied. Okay, however, what happens if the damage suffered by the person is not directly caused personal injury or property damage? Let's say the damage suffered by the plaintiff is nervous shock. Okay, is a duty of care owed where the plaintiff suffers nervous shock? Well, what is nervous shock? Well, it's a medically diagnosable psychiatric injury. It doesn't include worry, stress, or depression. It has to be shock-induced. It has to occur very quickly, okay? And the cases which are must-know in this area, everybody. First must-know case is Hinds and Berry, because Hinds and Berry gives us this requirement that nervous shock has to be a medically diagnosable illness, okay? And you'll find Hinds and Berry on page 72 of the course manual, okay? Page 72. Hinds and Berry is probably your first must-know case when it comes to duty of care owed for nervous shock. Okay, and Hinds and Berry is followed in a Hong Kong case called Wong and To, and Wong and To is, where's Wong and To? I know. But Wong and To says the same thing. So Hinds and Berry on page 72 up the top. The court held that the burden of proof is on the plaintiff to show that he or she has suffered a clinically diagnosable and recognizable psychiatric condition. Now, in exam questions, everybody, you'll be told pretty clearly that it's a medically diagnosable psychiatric injury, okay? Post-traumatic stress disorder is nervous shock, okay? But the plaintiff has to prove that they have suffered nervous shock, and of course you probably have to produce some sort of medical evidence to prove it, okay? So nervous shock appears the essential element for successful claim is that the psychiatric injury is caused by a sudden shock of some kind. So, you know, just sort of looking after somebody who's terminally ill and you sort of don't feel all that great about it, that's not nervous shock. It has to be shock-induced, okay? So if the psychiatric illness is caused by the cumulative effect of exposure to distressful events over a prolonged period of time, normally there would be no cause of action available for nervous shock, okay? So Hinds and Berry is the first must-know case on nervous shock, and Wong and To is a Hong Kong case which says the same thing. So, mere depression, distress is not sufficient. It must be shock-induced by, a sudden event, such as an accident. Traffic accident is a typical one. Or, you're walking along the street, something falls from a building above you, that could cause psychiatric injury. Okay. Now, whether or not a duty of care is owed when the plaintiff has suffered nervous shock does depend on whether they are what we call a primary victim or a secondary victim. So make sure you know the distinction between a primary victim and a secondary victim. A primary victim who's somebody who's actually injured. Okay, you could be physically injured and then also suffer nervous shock. So both your body and mind are affected. Or you may not be physically injured, or you could be in the line of impact. In other words, something has happened right in front of you and you're in fear of your own safety. You think you might be actually injured or killed yourself. So that if you are in the line of impact, then you are a primary victim. So if you're actually physically injured or in the line of impact in fear of your own safety, you are a primary victim. Okay? And if you're a primary victim who suffers nervous shock, the courts will treat you very much like they do a person who has suffered directly caused physical injury. All you need to do is show reasonable foreseeability of physical injury. That is sufficient to ground a claim for a duty of care. And the must-know case on primary victims is Page and Smith. But Page and Smith is your second must-know case on nervous shock. Okay? Hinds and Berry is your first must-know case because that says what nervous shock is. Then if the plaintiff has suffered nervous shock, you've got to distinguish between plaintiffs who are primary victims and those who are secondary victims. So a primary victim is, as on the screen, one who's actually physically injured or in the line of impact. So you may not have actually been injured yourself, but you're so close to it that, you're in fear of your own safety. And if that's the case, all you need to do is show reasonable foreseeability, which would be easy to show, then a duty of care is owed. Page and Smith. So that's sort of almost as if you are, Donahue and Stevenson itself. But there are other victims who are not primary victims. And can a primary victim also claim a duty of care is owed to them? Now, who is a secondary victim? Somebody who is not in the line of impact or physically injured. Okay, you're at a distance, so to speak. And we'll go through some of these cases in a moment. Just checking my notes here. The law has progressed a little bit. First of all, you got Delu and White, which is on page 72. Before, the courts were a bit reluctant to impose a duty of care where the victim is a secondary victim. And they were frightened that it might open the floodgates to lots of claims. But a more liberal approach was adopted in Delu and White in the middle of page 72. It was a case decided way back at the turn of the century, you'll notice, 1901. A pregnant barmaid suffered nervous shock when a carriage came off the road, crashed into the bar where she was working. She was not a primary victim, but she was a secondary victim. She miscarried due to shock, and the court gave judgment to her but confined the liability to defendant cases where the plaintiff suffered nervous shock as a direct result of the negligent act. In other words, they said you could only claim if you were a primary victim. So that's Delu and White. But the law then moved on, and 25 or so years later, Hambrook and Stokes, the plaintiff was a pregnant mother. The plaintiff usually walked her 3 children part of the way to the school and then left them to walk the rest of the way around a bend. And then when the children were walking on the bend and out of the mother's sight, the defendant negligently drove a lorry down the hill at high speed, lost control of the vehicle as he entered the bend. So the mother suffered nervous shock in her panic because she was scared that her kids were going to be killed. She didn't actually see it. And the lorry did kill her 3 children. So while only one of the children was in fact, killed 3 children, not her 3 children. She was worried, though, that her children might be killed. While only one of the children was in fact injured by the lorry, the shock left the mother to miscarry, and additional complications eventually caused her death. So in Pembroke and Stokes, the court said that in those circumstances, a duty of care would be owed to a secondary victim, okay, because there was sufficient proximity, okay? And what do you mean by sufficient proximity? We'll look at this in a moment. Pembroke and Stokes, the court said the mother was able to establish reasonable foreseeability, but sufficient proximity of relationship, and that was because she was the mother of the children. Sufficient proximity of time and space. She was there when the accident occurred, and she witnessed it for herself. Okay. Similarly, in Borehill and Young, a little bit later, top of page 73, the House of Lords in Borehill and Young said, in this case again, another pregnant lady. While alighting from a train, she heard a road accident in the distance, and upon reaching the scene of the accident, saw blood on the road, and therefore she gave birth to a stillborn baby, which she claimed was caused by nervous shock from the accident. The House of Lords held that the plaintiff was not entitled to compensation because she was not a foreseeable claimant. She was not proximate to the scene of the accident. So in Borehill and Young, okay, Corsell held that people were expected to be capable of withstanding the impact of witnessing injury to a stranger. So in Borehill and Young, it's possible there could have been a duty of care if there was sufficient proximity of relationship, but on the facts, the court found there was no duty of care there. So secondary victims can claim a duty of care for nervous shock, but they've got to satisfy 2 elements, that is the element of foreseeability and proximity. Borehill and Young, there's possible duty of care, but the lady involved was not able to show sufficient proximity. But now the law on secondary victims has moved on. So while these 3 cases at the top sort of interesting, they're all sort of history. The only must-know case in this area on secondary victims, in general terms, is the Alcott case. Now, Alcott's a very important case, and I think that, again, it's a case we need to focus on with a bit of concentration and focus on yeah. So it's probably a good time to have our second break. So we'll have our second break, and then we'll focus on this Alcott case. All right, so 10 minutes. Okay, everybody, so as it says on the chat box, into the final stretch. Good question before the break on Borehill and Young. In Borehill and Young, the court did find in the end that a duty of care was not owed, but the issue was, could a secondary victim claim a duty of care? Before Delu and under Delu and White, you could not even claim it, okay? In Hambrook and Stokes, though, the court said a secondary victim can be owed a duty of care, but you have to show the extra element of proximity. And we're going to look at this element of proximity in a bit of detail in a moment. There are actually three aspects to this question of proximity. In Borehill and Young, the House of Lords also said yes, a secondary victim can claim duty of care, but the secondary victim has to show sufficient proximity. And proximity has three aspects: proximity of relationship, proximity of time and space, and proximity of perception. And in Borehill and Young, the mother was not able to prove sufficient proximity of relationship. But the court, House of Lords, did say you could claim, but you've got to prove that extra element of proximity. And this law on secondary victims now is laid down by the House of Lords in the Alcock case, must-know case. Okay, so let's go through Alcock, because Alcock is a very important must-know case. Interesting case. It involved a rather nasty incident that happened at the Hillsborough Stadium. I think it was the home ground of Liverpool Football Club. And, 90 people, I think, were crushed to death. And so a lot of cases arose from the Hillsborough incident, and in particular, a lot of the people who suffered nervous shock sued the constable involved or the police involved, and their claim was the duty of care was for negligence, and that a duty of care was owed to them for nervous shock. Okay, but with regard to all these victims, they were all secondary victims. They were not primary victims. Remember, when it comes to nervous shock, you've got to distinguish between a primary victim, somebody who's actually physically injured and then also suffers mental illness. Well, then all you have to show is reasonable foreseeability. Proximity is sort of presumed. But you can also be classified as a primary victim if you're not actually physically injured, but you're in fear of your own safety in the line of impact, okay? And so, again, that depends on the facts of a particular case. But let's say you're walking along the street and an air conditioner falls down just in front of you, within 3 or 4 feet. You're not physically injured, but you get a hell of a shock. You could suffer nervous shock. You would be a primary victim. So all you need to do is show this element of reasonable foreseeability. You would not have to show the element of proximity because it's assumed, okay? So that's Page and Smith. Remember, the other must-know case on nervous shock is Hinds and Berry. Hinds and Berry says you can't claim a duty of care for nervous shock unless you prove nervous shock and prove it is a medically diagnosable psychiatric injury. So when you're dealing with this subject of nervous shock, draw up your list of must-know cases. Hinds and Berry is the first must-know case. It's got to be a recognised psychiatric injury. And then, of course, make sure you know who a primary victim is. Must-know case, Page and Smith. A primary victim, someone who's actually physically injured or was in fear of your own safety. You're in the line of impact. If you like, it was a near miss, but so you weren't physically injured, but you suffered nervous shock. Page and Smith, second must-know case in this area. The third must-know case is Alcock. Alcock says, if you are a secondary victim who suffers nervous shock, a duty of care will be owed to you only if you can prove both foreseeability and proximity. And proximity has three factors, or three aspects. You've got to prove sufficient proximity of relationship, sufficient proximity of time and space, and sufficient proximity of perception. Okay? Now, with regard to proximity of relationship, the court say that if you're in if you have a relationship of parents or spouses, there is the presumed proximity. Okay. However, if you're not a parent or a spouse in a spousal relationship, if you're in an other relationship, you've got to prove sufficient relationship of love and affection. Love and affection. And how do you prove that? Well, love letters, text messages, photographs, probably photographs these days because everybody's got a smart camera and, taking photos every day. And then, of course, here I am, got my arm around my good friend. Aren't we really? Boyfriend, girlfriend. Do you take photos of yourself? Boyfriend, girlfriend? Sufficient evidence, relationship of love and affection. Okay, good. And remember, in the Borhill case, the lady was not able to show sufficient sufficient proximity of relationship because the person involved was not even related. Okay, whereas in Hambrook, it was a mother and children, obviously sufficient relationship. Okay, so if it's parent, child, or spouses, there is presumed proximity of relationship. If you're in another relationship, you've got to prove close ties of love and affection. In Alcock itself, it was a claim by a brother his brother was killed in the crash in the Hillsborough Stadium disaster. He was not able to prove close ties of love and affection with his brother. Well, do you have a brother or sister? How close are you to your siblings? Okay. Well, some days you love them and other days you hate them. Okay. So he was unable to produce evidence of close ties of love and affection with his brother. So his action failed because he was not able to prove proximity of relationship. So the other two elements with regard to proximity, there must be proximity of time and space. And the leading case here is McLaughlin and O'Brien on page 73. And in McLaughlin and O'Brien, it was a mother who, she was also a wife because her husband and children were all seriously injured in a road accident caused by the defendant's negligence. She did not actually witness the accident, but she was taken to the hospital by a friend about an hour afterwards. So it's interesting, 1 hour afterwards. And of course, if you go to a hospital 1 hour after an accident, it's as if you saw the accident itself. You're in the immediate aftermath of the accident. And she saw all the gory details, blood everywhere, etc., etc. Her daughter had been killed. Her husband and two other children were very seriously injured. Well, that's a hell of a shock. And she did suffer nervous shock. And the court said that was sufficient sufficient proximity of time and space. And obviously in McLaughlin and O'Brien, there was sufficient proximity of relationship. She was the wife of the her husband was injured and also and killed, and her husband was killed. Anyway, well, there you are. You've got it there. And she told her 3-year-old daughter had been killed and her husband and 3 other children seriously injured. So a duty of care was owed to the mother in McLaughlin and O'Brien. She suffered nervous shock. She was not a primary victim. She was a secondary victim, but she was able to show sufficient proximity of relationship, sufficient proximity of time and space, particularly here, and also proximity of perception, because she saw the effects of the accident herself with her own eyes. Okay, and this raises the question then, what do you mean by the immediate aftermath of the accident? When she came to the hospital 1 hour after the crash, there is another case of Chung and Lam. It's a Hong Kong case, and Chung and Lam is this in your course training? But in Chung and Lam, it was a mother again, I think, on page 78. And in Chung and Lam, the plaintiff was the wife of the deceased who was killed in an accident for which the defendant was liable. So obviously proximity of relationship. And the mother then claimed that she suffered from nervous shock. But was there proximity of time and space in Chung and Lamb? And the court said no, because it was sometime later that she was told about the accident. So what do you mean by sometime later? So good question. So it does depend on the facts of each particular case. All right, so McLaughlin and O'Brien is the leading case here. Chung and Lamb is a good illustration, though, because it's good to have two cases with opposite conclusions. So they were both mothers, and in McLaughlin and O'Brien, obviously proximity of relationship. In Chung and Lamb, proximity of relationship, but in McLaughlin and O'Brien, there was proximity of time and space, but not in Chung and Lamb. So, I mean, begs the question, what happens if it's 2 hours after the crash, 3 hours after the crash? Well, that would depend on the facts of a particular case. And of course, if you're alleging or claiming a duty of care, you've got to prove all the elements, so it may be difficult to prove it. But it's worthwhile noting that the period after the crash in McLaughlin and O'Brien was 1 hour, okay? And the court said that's still sufficient proximity of time and space, okay? And then finally, there has to be proximity of perception. So, and secondary victims must have witnessed the event in person. You've got to be there on the spot. You can't have learned about it through third parties. That isn't sufficient proximity of perception. Okay? But the court in Alcott has left the door open slightly. What about in these days where we have live TV broadcasts? You know, it's as almost if you're there yourself. And so Alcott, which was decided back in the early 1990s, sort of look forward saying, you know, there may be a time in the future where you have these live TV broadcasts, you know, on big screens. It's almost as if you're there yourself. Could that ground a claim for nervous shock? Could that be sufficient proximity of perception? So the court in Alcott has left the door slightly open to people to claim that there's a duty of care owed for nervous shock when they aren't actually there in person, okay, where you have, you know, live, I mean, we're in this COVID lockdown mode, aren't we, at the moment? I mean, what about you people, everybody? Is my presentation today like a live broadcast, face-to-face? Okay. No, I don't. Well, if you're in a classroom, you'd be looking at the PowerPoint most of the time and listening to me. It's almost as if it's the same as face-to-face. Okay. I don't use the webcam because I'm not handsome enough. Okay. All right. So that's proximity of perception. So let's sort of recap that, everybody. With regard to nervous shock, let's quickly go through from the top again. Number one, when you get any question in the exam on nervous shock, and remember, if you are faced with this issue, it will be where normally there's a traffic accident of some sort, okay? And you're asked to advise somebody who suffers from nervous shock. Can they sue in negligence? Well, the only element in issue normally would be whether a duty of care is owed to them, okay? So if you suffer nervous shock, is a duty of care owed to you? Well, it will only be owed to you if you do actually suffer a recognised psychiatric injury, Hinsonberry, and then it depends on whether you are a primary victim or a secondary victim. If you're a primary victim, you'll be treated as if it's directly caused physical injury. All you need to show is foreseeability, and that's it. Page and Smith. However, if you're not a primary victim, somebody who's not actually physically injured or in the line of impact, then you'll be a secondary victim. Can you still claim that you are owed a duty of care? You can claim it, but you will have to prove the three elements of proximity, well, prove proximity with these three factors: proximity of relationship, proximity of time and space, proximity of perception. Okay, so always in an exam question, note the relationship. If it's a relationship of parent, child, or spouse, there is presumed proximity of relationship. If you're in any other relationship, such as in Alcock, brother relationship, sibling relationship, there will not be sufficient proximity of relationship unless you can prove close ties of love and affection. So you'll have to produce evidence of close ties and affection. So, you know, photographs would be strong evidence, letters maybe, cards, okay? You've got to prove it, okay? And in Alcock, the brother was unable to prove close ties of love and affection, so he lost his action, okay? And then also, you'll have to show sufficient proximity of time and space. McLaughlin and O'Brien is your must-know case, and McLaughlin and O'Brien, the mother came to the accident 1 hour after the crash. She saw the horrific effects of the crash, suffered nervous shock, and the court said there was sufficient proximity of time and space. Okay, and also there must be sufficient proximity of perception. Normally you have to experience it with your own eyes. Okay, third-party communication is not allowed unless, as Alcock did leave the door open for, unless it's perhaps a very graphic live TV simulcast that could possibly be sufficient proximity of perception. Okay, so must know Hinsonberry, must know Page and Smith, must know Alcock. Remember, Alcock gives us the 3 proximity factors, and then with regard to Alcock itself is also a case you can cite on the proximity of relationship. Time and space, the main cases McLaughlin and O'Brien, contrast Chung and Lamb, and then proximity of perception, well again you can cite Alcock on proximity of perception. Okay, so Alcock is the must-know case, and it's interesting because it happened quite a long time ago. Alcock, well, we're going on 30 years now since the Alcock legislation. It's still hitting the news occasionally because the legal action is still continuing in some of these cases. All right, so that's proximity of relationship, proximity of time and space, must know these 2 cases, particularly McLaughlin and O'Brien, and must know proximity of perception. Okay, so again, what about rescuers and employees? Well, again, will be treated the same as anybody else in a way. They will attract no but special treatment unless they are primary victims, and you would also have to satisfy the proximity requirements. So if you are a rescuer and you suffer nervous shock, which you might, although you would think professional rescuers should be immune to this sort of thing, but you never know. It could be a really horrific case. If you're a primary victim, no problem. You'd be able to show prove duty of care. But if you're a secondary victim, you would have to satisfy the proximity requirements as laid down in Alcock. And the case of White and the Chief Constable confirms that. Okay, so you've got to satisfy proximity as in the other psychiatric injury cases. All right, everybody, so that sort of brings us on to, slightly reluctant to get onto this because it's slightly, we can get onto it certainly by way of introduction. So what we've covered tonight, everybody, is the situation. Is the duty of care owed by the defendant to the plaintiff? Good question. And it does turn on what type of damage has been suffered by the plaintiff. If it's directly caused personal injury or property damage, a duty of care will be owed. All the plaintiff will have to show is reasonable foreseeability, full stop. So if you're in a traffic accident, a duty of care will be owed to you, full stop, if you've suffered personal injury or property damage. Okay? And we'll look at the driver's cases a bit later on when it comes. Mainly, the main issue in traffic accidents, everybody, is not duty of care, because normally the victim suffers personal injury or property damage directly caused. The main issue in traffic accidents when it comes to negligence is whether there's breach of the duty of care. That's going to be the main issue, when it comes to negligence cases involving traffic accidents. And we'll be covering breach probably next time we meet, but not tonight. Okay, so we looked at that. Also, we looked at the situation, is a duty of care owed by the defendant to the plaintiff when the plaintiff suffers nervous shock? Well, we just looked at that. Remember, Hinsenberry, Page and Smith, Alcock, McLaughlin and O'Brien. They're your must-know cases. Now, finally, with regard to duty of care, is a duty of care owed by the defendant to the plaintiff where the plaintiff suffers pure economic loss. Pure economic loss. What is pure economic loss? Pure economic loss is loss not resulting from personal injury or property damage. Okay, so we'll see that a duty of care will not be owed where the plaintiff has suffered pure economic loss unless there's sufficient degree of proximity. Okay, so it's a little bit, not exactly the same, a little bit like a duty of care owed for a secondary victim who suffers nervous shock, in that you have to show the extra element of proximity. Now, how close is the closeness? Well, I've got underlined on the screen, it's got to be pretty close. It has to be exceptionally close relationship of proximity. Okay, and we're talking here about negligent misstatements. And remember, negligent misstatement should remind you, everybody, of what we covered in contract law, namely misrepresentation. Okay, and remember, a misrepresentation can be either fraudulent, negligent, or innocent. So here we're talking about negligent misstatements, negligent misrepresentation. Now, of course, you know, if there is a negligent misrepresentation, you're probably wiser to go if in contract law. Contract law, namely misrepresentation. Okay, and remember, a misrepresentation can be either fraudulent, negligent, or innocent. So here we're talking about negligent misstatements, negligent misrepresentation. Now, of course, you know, if there is a negligent misrepresentation, you're probably wiser to go if in contract law, but also there could be liability in tort law for negligent misstatements, but only if a duty of care is owed. And the duty of care does require a very close degree of proximity. How close? Well, Devlin in the Hedley, Byrne and Heller case, which is on page 86, says it has to be equivalent to contract. Okay, so you can see, everybody, how closely, well, the overlap between tort law and contract law when it comes to misrepresentation. Okay, also Hedley, Byrne and Heller gives us a couple of elements here. There has to be an assumption of responsibility by one person. Normally that person is an expert who makes a statement, okay, and reasonable reliance on that by the other party. Okay, so Hedley, Byrne and Heller is the leading case on negligent misstatement because it changed the law way back in the 1960s. And Hedley, Byrne and Heller, where's Hedley, Byrne? I'm looking for Hedley, Byrne and Heller. There it is on page 86. Now, Hedley, Byrne and Heller, it was a statement made by somebody who was in the investment business, and there was reliance on the statement made by the expert, and the person relying on the statement suffered economic loss, pure economic loss. It wasn't loss as a result of personal injury or property damage, it was simply financial loss. They made an investment and lost money. Okay, so they sued the person who had given the advice, and was there an assumption of responsibility and reasonable reliance by the client? The court said no. Why not? Because there was a disclaimer in Hedley, Byrne and Heller. Okay, and what is a disclaimer? Well, you say, well, don't take my word for it. Okay, even though, okay, don't rely on me. So that's what a disclaimer is all about. But if there was no disclaimer in Hedley, Byrne and Heller, there would have been a duty of care owed, okay, because there was this assumption of responsibility and reasonable reliance on it by the other party, and that established sufficient proximity, exceptionally close relationship of proximity. So Hedley, Byrne and Heller is often cited as the leading case on whether a duty of care is owed for a negligent misstatement, okay? And we're talking here about the tort of negligence, okay? So some interesting cases on here. One interesting one, which is probably a good one to take us out on, is Chowdhury and Prabhakar. So in Chowdhury and Prabhakar, it was a young lady who wished to buy a car. And she went along and was looking at some cars. She took along a friend, a male friend, because, you know, ladies, guys supposed to be expert on cars and ladies not so much. Anyway, she said to her friend, hello, this car, is this a good car? Should I buy it? And the male friend had a quick look, said, yeah, it's okay, good price. So he made a statement about the quality of the car, okay, and he assumed responsibility for it because he's a guy, right? He knows about cars and she doesn't. And she relied on it, okay? And so she bought the car, but as it turned out, the car was worth much less than she had paid for it. So what was her loss? It was pure economic loss. There was no physical injury to her, no damage to her property. She had simply paid more money than she should have for the car. So her, if you like, her damage was pure economic loss. Was a duty of care owed to her? Well, the court says, was there an assumption of responsibility by the young man? Yes. He said, you know, you can rely on me. I'm a guy. I know everything about cars. And did she rely on it? Was there reasonable reliance? The court said yes. And the court found that there was indeed the, there was indeed a duty of care owed. Okay? And everybody said, this is a little bit strange because Hedley, Byrne and Heller, which laid down the requirements for a duty of care to be owed for where pure economic loss was suffered by the plaintiff, was a commercial case. Okay? Where, you know, somebody's an expert in the field and they're advising somebody who's not. But here we have a domestic situation, you know, sort of boyfriend, girlfriend, although presumably they were not friends after that because she sued him, okay? And so Chowdhury and Prabhakar is an interesting case because the court found that there was indeed a duty of care owed, even though it was in a domestic situation. They said, well, was there an assumption of responsibility by the young man? Yes. Was there reasonable reliance? Yes, there was. Okay. So Chowdhury and Prabhakar, interesting case. And so be careful, guys, if you're with somebody and they're thinking of buying a car, be careful what you say. What the young man should have said in Chowdhury and Prabhakar is this, don't take my word for it, okay, but I think it's a good buy. He should have had some sort of disclaimer, but he didn't have it, okay? So when it comes to duty of care owed, where the plaintiff suffers pure economic loss, well, there has to be a very close degree of proximity as shown by an assumption of responsibility and then reasonable reliance. And reasonable reliance was also shown in the Chowdhury case. All right, so these other cases we'll look at when we meet again on Thursday, so we'll follow up on this. But normally a duty of care will only be owed where the plaintiff has suffered pure economic loss when you're in a business context. Chowdhury is an exception, and generally it will only be owed if it's reasonable, okay, if the defendant has special expertise, okay, but in practice if you're a professional giving advice, you should always have some sort of disclaimer. Okay. I mean, you watch this in advertisements on TV, for example, somebody is giving financial, please don't take our word for it, etc., etc. So, and of course, we're in an area, everybody, where tort law overlaps with contract law. Okay. All right. So let's sort of wind back the clock a little bit, and let's have a look at what we've covered tonight. I'll have to go do that, but what we've covered tonight, everybody, is duty of care. And there it is. Sort of review of duty of care, but we haven't. So remember, duty of care owed by the defendant to the plaintiff. And how do you know whether duty of care is owed? Well, if the damage suffered by the plaintiff is directly caused personal injury or property damage, all you need to show is foreseeability. A duty of care will be owed. Donoghue and Stevenson. But proximity will be an additional requirement in other cases. And I've got the cases I've got on the screen, yes, but also you'll notice proximity was an extra requirement where there's nervous shock suffered by the plaintiff or where there's pure economic loss. Okay, so proximity is also a requirement unless it's directly caused personal injury or property damage. Okay, everybody. That's probably it for tonight. There you are. Directly caused physical damage. That's straight Donoghue and Stevenson. All you need to show is reasonable foreseeability. Okay. But in other situations, the plaintiff will have to show generally proximity as well. Of course, the court can always restrict the application of duty of care if they think it's fair, just and reasonable, or if the defendant is a public authority, such as in the Hill case and the police cases. All right, so we've covered almost everything on duty of care tonight. We'll review all this on Thursday, and on Thursday we'll be getting started on the second element of negligence, which is breach of the duty of care. Okay, and so read ahead so you're up to speed on that. And duty of care is often a key issue in traffic accident cases because usually the driver will owe a duty of care. It's almost automatic, Donoghue and Stevenson, particularly if the damage is directly caused personal injury or property damage. But the big issue in traffic accidents, everybody, will be this element of is there breach of the duty of care? Okay. The other elements are normally there, causation and damage. Okay, obviously damage has to be caused. Causation is a separate issue too. We'll have to deal with that. Causation is must know, but breach is definitely must know, and we'll deal with breach when we meet again on Thursday. So on Thursday, we'll review what we've covered so far on duty of care and finish it off, and then we'll be covering breach of the duty of care and probably get on to causation as well. So there we're getting well into the tort of negligence. Okay, everybody, that's it for tonight. Thank you very much for your attention. Some good questions tonight. And we meet again on Thursday. And when we meet again on Thursday, I won't be in this room. I'll be in another room. Okay, and see how we go with that room. Every room I go to has a separate setup. All right, well, enjoy your hot chocolate, have sweet dreams, have a dream about interesting cases on tort law. I hope you don't suffer nervous shock though. Okay, all right, thank you very much, and I will catch up with you on Thursday.